Hi there and welcome. My name is Madelena Viksne. I'm an employment lawyer at Samfiru, Tumarkin. And I'm here to answer some questions that you might have today. I thought I would start off first by sort of speaking about some of the issues that arise with work from home in terms of your rights as a work from home employee. One of those issues is whether or not the employer still has a duty to accommodate you pursuant to the Ontario Human Rights Code. The short answer is yes, those obligations do continue, even as a work from home exclusively employee. They could also be triggered by a new work from home employee by way of requests for things like different tools or office furniture or things like that may be needed for the completion of your job based on anything that has come up in the last 2 years while you have been work from home. So these accommodations do not need to be things that pre-existed your work from home period. And while your employer isn't required to furnish your home office, any requests like related to equipment should be dealt with by employers with a view towards their duty to accommodate you. Another issue that's been being discussed recently is whether WSIB continues to apply for those employers who pay into it. It does still apply as long as the injury takes place in the context of your employment. So WSIB will evaluate factors such as like the time, did it happen during work hours, the place, did it happen where you usually work? Obviously, walking your dog does not qualify, even if it's during work hours, because it has nothing to do with your employment. And so that's the other thing. The activity something that you would normally be expected to complete during the course of your duties. Employers are still obligated as well, and even as a work from home employee, to report your injuries and illnesses as per the WSIB's regular processes, and should also turn their mind to minimizing any potential risks of injury that could arise. And that kind of plays back into the accommodation issue. If there's somebody who's saying, this is really causing me a lot of strife and issues at home, working with this particular piece of equipment isn't working for me, that's an accommodation, but it would also fall under the WSIB sort of obligations to minimize risk of injury related to workplaces. So somebody asked, is it considered a constructive dismissal if you're put on idle? It depends in part on your contract, the termination clause in your contract, and whether or not there is a layoff clause present will both have an impact. But if you have been put on idle and you are interested in considering a constructive dismissal claim, I would suggest that you contact our office and speak to somebody about your specific scenario so that we can review whatever documents you have and determine whether that would be best for what the best way to move forward would be. Do I have the right to ask if my employer has completed a privacy impact assessment with regards to them asking about vaccine status? Another question, if I don't disclose, can they terminate or lay me off? I'm not sure what you are referring to with respect to a privacy impact statement. Generally, you are allowed to disclose your health information at your own will. Things like the privacy acts in Canada don't actually cover your disclosures with respect to an employer. They only cover the disclosure of healthcare practitioners to other individuals or organizations, and then how the information that those healthcare practitioners have disclosed is used by those used and protected by those whoever received the disclosure. So for you disclosing yourself, I'm not sure that it would apply. If you don't disclose your vaccine status, can they terminate you or lay you off? The reality is this is a practical, not a legal question. If you are not willing to disclose your status, you will be treated as an unvaccinated employee, and whatever consequences come from that are bound to be applied to you as well, because without a disclosure, your employer can't be sure one way or the other. That being said, the options really are to disclose your status and see what happens, and whatever consequences come from that, or to get vaccinated. There's no way to preemptively prevent a termination. So, if termination is a consequence that you're seeing happening in your workplace, it's certainly possible that that could be a consequence that you could face, based on the fact that you would be considered unvaccinated unless you make a disclosure otherwise. Um, I don't work in insurance. So the next question is if we can get it documented in an email that our work life insurance will not pay out in the event of an experimental COVID vaccine related death, would that be a legal reason not to get vaccinated? Um, I don't work in insurance, so I can't speak to that. You'd have to speak to the insurance provider. Can you be terminated for cause for refusing to get vaccinated? Um, it's our position that it's not termination for cause, that it doesn't reach the high threshold required of for a cause termination. A cause termination means a termination without pay or notice. Um, it's our view that it is not sufficient to reach the higher threshold for that. However, you can be terminated. If you were terminated or are terminated for cause for refusing to get vaccinated, I would again suggest that you contact our office and have one of our lawyers look into your specific situation, review the vaccine policy, and have a discussion with you about the facts of your particular case and situation. But in terms of whether not being vaccinated amounts to cause or refusing to be vaccinated amounts to cause, the position that we are taking is that it isn't. Now, with that being said, these cases have not been tried in the courts at this point in terms of cause terminations or whether the unpaid layoffs relating to vaccinations specifically. We don't know at this point how the courts are going to treat them. So it is a bit of a live issue within the legal community, and we have to wait for a decision to come out at this point. When put on a leave of absence because of not complying with vaccination policy, what happens to benefits like dental? If they're private health benefits, if you're on a leave of absence or a layoff, they should be continued. Now, that being said, there may be a scenario where you pay some portion of the benefits yourself, and if that's the case, it would normally come out of a paycheck. Obviously, you're not being paid when you're on a leave of absence, so it is possible that your employer would contact you to ask you to provide them with payment for whatever the portion of those benefits are that you would normally be paying for out of your regular paycheck. But they should generally be continued unless you've been advised otherwise. Are non-compete clauses banned in Ontario due to the passing of Bill 27, even if you sign the agreement before the bill or after the bill? They are generally not permitted in Ontario anymore. They won't be enforceable. However, there are a number of different exemptions or exceptions within Bill 27. So it would be important to review those to ensure that you do not apply to one of them. Again, you can contact our office. We can review the contract or non-compete agreement that you signed in concordance with the bill and make sure that one of the exemptions does not apply to you. However, in most scenarios, non-compete clauses are not going to be enforceable moving forward. Does switching to working permanently from home change my employment entitlements? I used to be full-time in office, but I will likely never return to this setup. Randolph, if you can just clarify what it is that you mean in terms of employment entitlements. I'm not clear from your question whether you are referring to things like pay and benefits or something other than that. That being said, before you clarify, I can say that your pay and benefits should not be changing your compensation should not be changing in the context of a work from home situation. Any reduction in pay or hours without your consent is potentially a constructive termination, depending on the circumstances of your particular case. So if you continue to work from home and your employer is happy to have you do that, and you're not going to be full time in office again, there shouldn't be any change to your compensation on that basis. However, it's difficult. It's difficult for me to say that that's a fulsome answer, given that I'm not exactly sure what you're meaning by entitlements. So you clarified that you work in a different province but live in Ontario. Your contract doesn't stipulate where your place of employment is. So I think that what you're asking is, can they change the terms of your employment to say that you have to be working in whatever other province now, moving forward? If that's what the concern is, if it's not in your contract, it would constitute a significant change to your terms of your employment. And if that does become an issue, again, I would advise that you speak to a lawyer and have them review sort of your contract and the circumstances and what demands are being made of you by the employer in order to determine, what that exactly will, how that might play out. It will largely depend on the position that your employer takes with respect to your working from home or working from a different province. There could be tax consequences related to where it is that you're living versus where it is that you're working. So there may be valid reasons for them to require that you live in a specific place. If at this point they haven't, I would wait until that is made an issue, because I don't see the reason. I don't see a benefit to you to raising it as an issue until it's been raised as an issue. However, it may be worthwhile to sort of preemptively speak to somebody in our office to determine whether or not it's something that you should be concerned about moving forward, or what your options are, how to approach it if they do come to you and seem to change their minds on that point. So Lynn, your follow-up to the previous question, which is that whether you could be terminated for cause, is can they refuse severance pay, when I assume you mean terminating you for cause. If you're terminated for cause, there is no severance pay. The purpose of a cause termination is there's two different things here. A cause termination means essentially that you'll be terminated without reasonable notice. You may also be terminated pursuant to the Employment Standards Act in Ontario for willful neglect, disobedience, or willful misconduct that is not trivial and has not been condoned by your employer, in which case you also wouldn't receive your ESA minimum payments. There are very high thresholds to meet, especially the termination without any severance pay or notice under the Employment Standards Act. So as I said before, we are taking the position that termination for cause or without any severance is not an appropriate response with respect to vaccinations. However, if they are alleging cause, you will not receive termination pay, most likely. And that would be something that you would need to bring to us, and we can help you move forward in terms of pursuing whatever payments may be owing to you and challenging the cause allegation. I hope that helps. With respect to your question, Laura, in terms of the fees for reviewing individual cases, the best thing to do is to contact our intake department, and they will do a brief intake interview with you. And during that interview, they will sort of analyze your case a bit, and whether or not you will be, what your costs would be in terms of consultation would be determined at that point by our team there. So we would need a bit more information about what the individual case involves and what issues we're dealing with before I can sort of advise on costs at that point. Mark is asking, can my employer change the percentage of commission I receive as a result of the pandemic. This will really change how much I can make in a year. It Commission plans are often subject to some changes. Whether those changes are permissible or not, it really depends on the language of the plan. Um, there have been a number of cases where employees' wages or um, hours have been reduced as a result of the pandemic, specifically for the purposes of being able to keep those employees employed. Um, if you've made an agreement with your employer like that and signed anything, then there may be sort of a defense on their side for making those changes that you're referring to. It really will depend on what the changes are, how much of a change it is. Like something like a change of 20% in terms of what it is that you're taking home at the end of the year is obviously extremely significant. Um, a smaller change in terms of what you're taking home may not be sufficient to reach the level of a constructive termination. If you've consented to the change, again, it may not be possible to establish a constructive termination in that case. So it's really going to depend on the facts of your case and what the commission plan documents in your contract say, and sort of what discussions were had with your employer ahead of time. However, if the change is significant and you didn't consent to it and it's been unilaterally applied, I would certainly suggest contacting one of the lawyers at our office through our intake department to have a thorough review done of your situation, so that we can determine, if there's enough there to establish a constructive termination and advise as to next steps moving forward. Lynn, each case is an individual case. I'm not aware of any specific class actions with respect to cause terminations for vaccinations. It's a complicated thing to do, to bring a class action, and it takes an extremely long time. So most of the time, people are better served by going after their employers in these types of situations on an individual basis. There are a number of cases that we're expecting to see come through the courts, which will provide us with a bit more information. But litigation is a long process. It's not super quick to get from sort of the point where you speak to a lawyer until later on, and a lot of cases settle. Most cases, in fact, don't make it to a courtroom in the end. So at this point, I'm not exactly sure what the timeline is in terms of us getting any answers, but we do know that there are cases that have been put forward and are working their way through the various steps leading up to that point. And there will be more clarity on these issues once a decision comes out. How long does it take normally to get severance from large corporations? I've been suspended without pay since December until I prove that I took the vaccination. It's difficult to say. To be honest, it completely depends on the employer. I wouldn't anticipate that many, in my experience at least, I haven't seen that many employers who are super forthcoming with the money in the context of a vaccination termination or layoff. So it's a bit, it can be a bit longer than we might have seen outside of the COVID context. I would say anywhere from 3 to 6 months to a year plus. It really depends on the circumstances of your particular case, and I don't personally have knowledge about your employer that you've set out there, but that doesn't mean that it would necessarily take any particular amount of time. It also would depend what counsel gets assigned on the other side of a file. Some are advising their clients differently than others, so it's difficult to say. But I would suggest that if you're thinking about pursuing a constructive termination claim due to the suspension, that you contact our intake department to speak to one of our lawyers. or to set up a consultation to speak to one of our lawyers, and that way we can give you a bit more information about what the process in your particular case might look like, as well as how long it's anticipated in the event we may be able to give you a more particular time frame in the event that we have other files against any particular employer. I'm unaware of that at this point with respect to the employer that you've set down there. How do we navigate childcare accommodation amid rolling school closures? What are we allowed to request as employees? This is a good question. Thanks, Belinda. So your employer has an obligation to accommodate you under the Human Rights Code on the basis of family status. And what that means is your obligations as a caregiver or mother, parent, son, father, so on. So any sort of family-related obligations outside of your marriage, which would fall under marital status instead. But your employer has an obligation to accommodate you under those that heading of family status. And this would include providing you with accommodation in the basis of in the circumstances that you're referring to with respect to childcare issues. One thing that I would suggest that you do is explore other options for accommodation, or for dealing with the childcare issue before going to your employer. So you make calls. I don't know how old your children are, of course, but make calls to daycares and have a list of the daycares that you've called, or make calls to try and maybe do some pod type of organization, because when you go to your employer, you want to be able to say, listen, I've explored all of these other options, none of them is available, or they're not affordable, or they're not open, not possible for me, and therefore I need to be allowed to work from home in order to be able to be there to care for my child, or I need to have flexible work hours during the day so that I can assist them with school, but I will make up for those, any missed hours after 7 o'clock when the kids are in bed, or whatever. I mean, obviously these timelines and things are dependent on what your specific situation is, how old your kids are, what kind of care they would require in the first place. But I would advise looking into other potential options, just so that when you have that conversation, you can say, look, I've done a bunch of things to see if I can make this work. I can't. And then once you make that request, your employer is obligated to accommodate you up to the point of undue hardship. So undue hardship is quite a high threshold, and it usually has to do with costs, and an analysis of whether or not the costs would create such a burden on the employer that it's impossible for them, or close to impossible for them, to accommodate and continue to function as a business. So you've now asked, can your employer claim frustration if they say your childcare needs cause too much of a disruption in your work schedule? I would think not. Frustration is again, it's difficult to prove. It requires that an unforeseen, unexpected event has sort of happened that makes your contract impossible to perform. School closures, your kids being homesick, even a lot of things relating to COVID in terms of business slowdowns and things like that, in our view, don't amount to frustration. It has been an argument that's been made that contracts were frustrated when COVID happened, and so far there hasn't been a decision that conclusively agrees with that argument. So I can't really see a scenario where your employer would be able to say that your childcare needs and their duty to accommodate you is sufficient to amount to frustration. Now, if you're having these conversations with your employer, it sounds like it may be time to contact legal counsel, so that we can help, at least from behind the scenes, potentially help you navigate these discussions with your employer. I don't know if they have made the comment that it would amount to frustration, or if that's just something that you maybe researched on your own. But certainly if they're making claims using that type of language, I would suggest that you speak to a lawyer sooner than later. Um, my employer told me that I have to be off work for 10 days because my wife just tested positive. She's already symptom free and testing negative the day after she had the positive test, but my employer will not let me back before the 10 days are up. Are they allowed to keep me on a forced leave? They're mandated to. They're required to ensure that all employees are complying with the Ministry of Health guidelines. So as a result of the Ministry of Health guidelines, if you've tested positive or if anybody you've had close contact with has tested positive, you're required to quarantine for 10 days, even if you're not symptomatic. It doesn't sound like you've done a test yourself. So that could also be an option that you could explore, but there will still be a quarantine period required of you. There are a number of paid sick days available pursuant to the Ontario law. So you should be looking into that if they're putting you on leave without pay, or speaking to your employer about the fact that that's causing you hardship. Yeah, Ryan, Lynn's asking if we could please put the number up for contact. So could you put up the Toronto number for her? It's there for you now, Lynn. Are employers allowed to change when an employee receives overtime with an agreement? Sorry, the dreamer, I'm not sure that I understand the question you're trying to ask. This is going to be the last one that I answer here, but if you can clarify quickly, I will try to answer in the time we have left. Oh, sorry. I think what you're asking is, can they pay it out at different points? Like if you sign an agreement, can they pay it out in a different way? It depends on what kind of an agreement you're referring to. If I'm correct that that's what you're asking, it would depend on the type of agreement. If you're talking about an averaging agreement, those are between your employer and the Ministry of Labor. And so because of that, if you've signed it, you've agreed to whatever terms there are with respect to averaging your time. If you mean that you're not receiving it on each paycheck, I'm not sure. It would probably depend on the terms of the agreement that you're referring to. But if you have concerns, you can contact our office and send your contract and the agreement to one of our lawyers to take a look at it and inform you further. So that's all we have time for today. Thanks for your engagement, everybody, and we will see you again on Wednesday, tomorrow with Lior Samfiru. He'll be here answering more questions, and I'll see you in a couple of weeks. Okay, thanks so much.